Hey, young people. Well, man, I'm getting a lot of complaints about freaking the audio. I'm sorry. I'm not adjusting anything. Quit complaining about freaking audio. The audio sucks in this courtroom. If you can find it better somewhere else, then haul your freaking ass and quit crying in the comments. Some of you have tried to give me constructive criticism, and I appreciate it, because I don't know how to adjust the audio. I did notice on my video recorder, it says ducking is at 90%. I don't know what the hell that means. I tried to look it up. It looks like something about overcovering or shadowing or some shit. So I think I turned the ducking down to 50%. Maybe that will help. So I just went and let the possum out that I caught last night. And I come back and they're talking jury deliberation. So let's see what the hell's going on.
With the same appearances, except the jury's not here, and we're here to talk about instructions and verdicts. And the district attorney has requested a multitude of lesser included offenses.
Okay, he said the district attorney has requested a multitude of lesser included offenses. That means we didn't prove our case, so we're going to fill the jury with a bunch of bullshit charges of lesser included offenses. So if you have attempted murder, you could have a lesser included offense of use of a gun, assault with a gun, assault with a deadly weapon, terrorist actions in a crowd, inciting a... I mean, there's just 1,000 different things in the laws that everybody's supposed to know, because ignorance of the law is no excuse, that you can come up with. And the district attorney went back and go, you know what? This guy ain't freaking walking. They may not get him for freaking murder, but I'm going to give him a whole bunch of other shit. They got to convict him of something, and then I'll go for max sentences, because this guy's definitely a menace to society. He's out there trying to remove spray paint and protect property, and he's a gun carrier, and he defended himself. So we got to get him off the streets. Shit. We got to take away his right to vote so we can convict him of a felony. We don't want guys like him voting. Fucking crazy trial.
Are any or all of them opposed?
Judge, I'm looking at their, sorry. So, I have count one, just the first degree, I'm sorry, the first degree reckless homicide. I didn't see any lesser included on that.
They asked for 1020. Did you get their written request for instructions?
I did.
They asked for 1022. Oh, yeah, there was an email last night. Did you get that?
I did.
Okay, they asked for 1022, which is not the standard for first degree reckless homicide. It's the standard for first degree with a lesser included of second.
Okay.
Okay.
We're not asking for that, but I understand the court may get it.
Okay.
This
Are
guy
you
never
objecting to its giving?
freaking talks on a microphone.
Yes.
Want to discuss it briefly, or just impose or argue, object for the record?
I guess I would just object for the record, Judge.
Okay. All right, then. I'm not going to decide right now, because I just got your filing this morning, which was sent to the clerk in Kenosha. They sent them to me directly, and I know you're not familiar with that procedure. So,
Okay.
and actually, I wish less people had my email right now. But I think that's probably a common feeling.
I just put my headphones on.
So
So if the sound changes, let me know. It's at 440 that the sound changed, because I plugged in my headphones to one of the speakers. So sometimes my microphone picks up the speakers that I'm listening to. and he creates a little bit of feedback. But normally, I mean, I've never gotten so many complaints, and I'm like, dude, I can't control what they do in the courtroom. Anyway, here we go.
What I plan to do is to send, at some point tomorrow, I will send you what I expect to deliver as the final instructions and verdicts. And I would now, given the evidence, well, I'll leave it at that. And then we probably will have what I hope will be a brief discussion on Monday about it, and at least you'll have
I gotta speed this up. We'll be here all freaking day.
admits second degree, and it's in the instruction itself on the bottom of, well, I don't want to say bottom because I don't have them displayed as they would on the page, but on the instruction you requested, which is 1022, under the heading difference between first and second degree reckless homicide. It says the difference between first and second degree reckless homicide is that the first degree offense requires proof of one additional element, that the circumstances of the defendant's conduct showed utter disregard for human life. And of course, the standard for submitting the lesser is that there's ground in the evidence to acquit on the greater and still convict on the lesser. Where's the absence of evidence of utter disregard for human life?
Judge, there was a line of questioning on the cross-examination of the defendant in which Attorney Binger asked.
His audio just changed, and I didn't touch shit, so quit crying.
I believe in regards to each person shot or shot at, except for that of Mr. McGinnis, I suppose. If the defendant, I can't remember the exact wording, but if he even cared if he killed the person alluded to. So I believe that the defendant denied that he said he had to shoot him. He denied that he did not care about their life. So I believe the jury could find, based on that line of questioning, as well as just the evidence in general, that.
So when they're asking these questions, remember, they're trying to trick you up to get you to take one stand or the other. So if you don't say I meant to kill him, you get charged with murder. If you say I didn't think about his life because I was just thinking about self-defense, now they're going to say you don't care about life. Welcome to government tyranny, people. This is not about doing the right thing and protecting freedoms and allowing good people to defend themselves against bad people. And everyone should be concerned with that, including the stupid, dumbass little liberals that keep coming here calling him a racist and he doesn't like black lives and they should have killed him. And I mean, the comments that I'm censoring is all from the left-wing loons calling for violence, which YouTube has no problem with. If I said any of that, they'd be taking down my video, give me a strike.
That the defendant did not have an utter disregard for human life, as he testified. He testified that he essentially had regard for human life because he felt he had to do it, and he didn't really want to kill anyone.
Well, the circumstance. Well, let's hear from the defense.
Element 3 is the circumstances of the conduct showed the utter disregard for human life. And in terms of the evidence in the case, I think the testimony was he didn't want to have to do it, but he did it to defend himself. So, as I said in our instructions, I don't think that there has been any evidence offered which would support the lesser included on count 1. So I would ask the court give 1020, which is the first-degree reckless homicide charge, along with the self-defense instruction, and that'd be that, because I think that's what the evidence shows.
I'm going to do a colloquy with your client when we get done with all this. And don't let me forget, please.
I've discussed it with him.
Yeah, but I got to talk to you personally. The instruction says, in determining whether the circumstances of the conduct and that.
Did he say I have to talk to your client personally? I'm not sure what he's talking about there. Like a private meeting?
The correct point. The conduct showed utter disregard for human life. Consider these factors. What the defendant was doing. He was firing a gun into, let's see, this is count 1, so we're talking about Mr. Rosenbaum. He was firing a firearm 4 times into a human being with fatal consequences. Why?
Which cops do every day, and we're never discussing this.
He was engaged in that conduct. How dangerous the conduct was, well, that's self-evident. How obvious was the danger, that's self-evident. Whether the conduct showed any regard for life, and all facts and circumstances, I don't see it. And I don't see it. Help me out where I'm going wrong.
Judge, he was asked if not only did he how he felt about killing them.
This is another reason you don't want to put your client on. They wouldn't be able to argue this if he didn't have any answers. So by putting him on, did they gain or did they lose? That's the risk of putting your client on.
But if he knew that his conduct would have killed him and that firing the gun would have killed someone.
This element is, on first degree, which is what we're not talking about, is whether he knew or was practically certain, and we're talking about reckless endanger or reckless homicide. So, I mean, to fire a gun 4 times into somebody, you don't think you'd know or have or be practically certain that could have fatal consequences?
I would, but the defendant denied that it would.
He didn't. I didn't hear him deny it. He said he was protecting his own life. I thought he was, when he was being asked repeatedly, and correct me if I'm wrong, he was asked repeatedly questions along the line that you indicate, and he responded, "I was trying to defend my life."
He was also asked the line of questioning, you knew if you shot 4 shots that you would kill him, and he denied that he would have that knowledge. So I agree that, I obviously think that it's utter disregard because that's what we charged it as, and that's what we have presented to the jury, but I believe a reasonable jury and a reasonable juror could, based on the defendant's own testimony, not find utter disregard for human life, and that's the standard, not what we.
He really cares about a reasonable jury thinks, right? Or is he just trying to throw shit against the wall so they don't lose every charge and they look like total idiots? Let's throw out a bunch of other charges so maybe they'll convict him on one. What a crooked prosecution. Wow. And he's got a new little pin on today. What's that little pin mean? Maybe his boyfriend gave him that. Here we go.
Think, but what a juror could do.
I wish I knew the exact answers that were given. I'm not sure, and I when I say that, it doesn't mean I'm embracing your interpretation of what that would mean, but I would want to be sure exactly what was said anyway. So, are you able to identify when in the examination? Because you had a very lengthy examination.
Check my notes.
And, unless it's crystal clear, my suspicion would be if it turned out that the defendant would be acquitted, well, not acquitted, but if the jury returned a verdict on second-degree reckless endangerment with this description of what constitutes the crime, if they returned a guilty verdict over the defendant's objection, I would expect to be reversed.
On second-degree reckless endangerment?
Yes, or homicide, I'm sorry.
So, you're saying if the jury finds the lesser
On this charge,
and the defendant objected,
over the defendant's objection,
and you accepted it,
right?
you felt it'd be reversed?
Yes. Unless you can come up with this crystal clear language that the defendant, and again, we're back to the circumstances of the defendant's conduct showed utter disregard for human life. So I think.
Remember, people, ignorance of the law is no excuse. You should know everything they're talking about. Wow.
His thoughts on the subject would be relevant, would be a legitimate factor, but when I consider the others, what he was doing, firing into somebody 4 times, why he was engaged in it, there's a dispute about that, but either it was it would certainly be reckless under any circumstances, and except under privileged circumstances. How dangerous it was, how obvious was the danger, and whether the conduct showed any regard for human life. And if anything, it seems to me he would have indicated, if you interpreted his answer, it would be an indifference. Although he did say at one point that he didn't want to kill anybody, but it would be an indifference because when he's asked about his intent, what was the question you were saying again?
Very critical that he said, I did not want to kill anybody. My intent was never to kill anybody, etc. They got to prove that you intended to charge those higher charges.
There was a line of questioning on if he cared about killing someone or cared in that regard. And there's a line of questioning is you knew that firing the gun could cause death, and I believe he denied or indicated he didn't know.
I don't remember that. Did
Everything that he said, the reality is everything was an intentional act. Now, they haven't charged it that way, and I appreciate that. But looking at the definition of utter disregard under the statute,
He just gave the defense an idea. Because he said he intentionally did everything.
I'm not going to repeat. I'm going to hold the same ground that you've already done. Firing 4 shots, we have evidence that the man grabbed the barrel of the gun. So we're talking about a distance of inches. Not always feet, but in some situations, inches. It is the only logical conclusion would be that a person would believe that that conduct, if they were convicted, would show an utter disregard for human life. If self-defense isn't accepted, there's no other reasonable conclusion that can be drawn from firing a gun somewhere between 1 and 4 feet, all the way down to inches, by the soot on his hand. So I think that's what the evidence showed, and I think that's really the only evidence regarding the utter disregard portion of the statute. So
If the defense is going to stipulate to the third element, then that's fine. We can go with that way. But it seems they're not arguing it. And if we want to go that way, then we can.
Conversations with lawyers are always interesting.
If they're not going to stipulate, then obviously there must be some disagreement, or they must be trying to argue it. So I believe that there is a basis. I cannot recall at this moment precisely where in the cross-examination it occurred. Obviously it was lengthy, and I wasn't the one conducting it.
The examination, as I recollected.
Obviously, I wasn't conducting it. The guy that conducted it is sitting next to him, and he can't ask him. He's got to play dumb. I mean, the courtroom theatrics in this, and it's this way in all trials. I mean, it's not just this one.
Was that the defendant was repeatedly asked about the question about his thoughts on the subject of the death or survival of the target, and invariably responded that he was trying to defend himself and that he'd be killed if he didn't. And if anything, I would interpret it as an indifference towards the outcome with respect to the target, which is not identical to utter disregard.
Right. Right. So if he's indicating he has an indifference, that would be second-degree reckless homicide.
Now, it would be one factor, and I don't, even if I granted, but I just don't think it's appropriate. And as I'll repeat my statement, if I were to give this instruction over the objection of the defense, and the jury found a verdict on it, I would expect to be reversed.
Well, are we in agreement that element 3 is present?
Well, don't ask me. I'm not in a position to agree to anything. I'm not going to give that instruction. Or submit that verdict. 1345 and 1347. Second-degree reckless endangerment.
So it's essentially the same issue.
Yeah, it is. So, any additional argument on that?
It would be the same for count 3 as well. Well,
Notice the little weasel?
Counselor makes a good point to me that he claims he didn't even know Mr. McGinnis was there, so he's firing a weapon he admits does not know the capabilities of. He admits he doesn't know how the bullets can react. He did not know if a metal jacket could pass through his target, and he's really showing utter disregard for anyone in the line of fire as he fires 4 shots, including Mr. McGinnis. There's also bystanders. There's a house directly behind Mr. McGinnis. So I believe in firing 4 shots in a somewhat, I would say, wild manner. He is showing that there could be an argument that he says he didn't. I believe again that it's utter disregard, but a jury could find, because he did not know Mr. McGinnis was there, that he was not showing utter disregard for Mr. McGinnis' life, and that the second degree endangerment would be more appropriate.
Defense?
just give me 1 second, Judge. Because it stems from, and tell me if I'm wrong on this, because it stems from the actions involving Mr. Rosenbaum, which this court believes the proper instruction deals with the utter disregard for human life of Mr. Rosenbaum. Those actions, to me, are intertwined with the charge involving Mr. McGinnis.
No, I don't think so, because I think the instruction anticipates that he could have utter disregard for.
Look how long it's taking 5 lawyers, if you count the judge as a lawyer, or 4 lawyers and a judge, to try and determine what is right, and they're going to read it once to the jury in a list of multitude and tell the jury to make the right decision. Which is why, if you're on a jury, I mean, our jurors have to learn that when you're on a jury, your default is not guilty unless the DA just proves beyond a shadow of a doubt. They like to say reasonable doubt, and they like to tone down the word reasonable. It's bullshit. The government has all the power and all the ability. Those 2 attorneys and those investigators, when you work a homicide case, you can work that for a year or 2, and that's all you do. You don't do anything else. Every day, 8 hours a day, overtime, etc., at night. That is all you're doing to get to trial. And then before trial, shit, you're working 18, 24. I mean, it's just crazy the amount of hours you'll work straight trying to get shit that's missed, or, oh shit, we don't have this, we need to go find this person. Oh, I wanted to call this and I didn't, we need to go find that person. So it is a huge amount of money and time put into this for a guy that was out there removing this, and a bunch of rioters were attacking him, trying to start fights all night and lighting fires and destroying property. And we want to put this guy away for life. Man, our system is just so broken. And this is just one part of it. Our politicians are broken. Our spending, our government, the FBI is freaking KGB lying, obstructing investigation, making up shit. I mean, our system is broke.
Could have utter disregard for the life of Mr. Rosenbaum, but still be sufficiently aware to realize the risk to Mr. McGinnis, and then he, under the law, as I read it, he would have the obligation to exercise.
I want you to remember how many times I've showed videos of cops spraying and praying, shooting people with no guns, shooting the wrong person, shooting people in the house by accident. How many times we have seen cops do 10 times worse than this, and there's never been a charge. That's why all you idiots out there that think, oh, cops are heroes and they're great, it's bullshit. If they were held to a high standard and they only did good work, I got no problem supporting them. But they are held to such a no standard. They're like the vaccine companies. They get immunity. They can't be charged. They can't be sued. I mean, it's just ridiculous that people don't have a problem throwing a 17-year kid under this legal bus, and yet cops run around and do 10 times worse every day. And it's never questioned, ever.
His conduct is in such a way as to minimize the risk to Mr. McGinnis, whether privileged or not. He would, let's talk about his conduct being purposeful, even though it's not charged. If he intended to kill Mr. Rosenbaum,
He didn't.
and whether he was justified in that or not, he's still required to execute his intentions in a way with the minimal, or to minimize the risk to Mr. McGinnis. So if, and that's a jury determination, I'm not suggesting I would want to be in that position, who would, but he would have to decide, well, I've got to kill this guy, but I've got to do it in such a way that I don't hit anybody else.
Really? Do cops think of that? Have you ever seen a cop up here getting questioned by a DA or a judge when they spray and pray relentlessly? I showed cases, 600 rounds fired into a building because a guy ran inside it. I mean, it's just crazy, and no cop is held accountable. Yes, granted, every once in a while you're seeing a cop going to jail, but it's only because of color. It's not because of they're out of way. They're going to jail because it was a white person on a black person. You do not see cops in general held accountable when they fire rounds, which is why they spray and pray all the time. This kid used more reserve than 99% of the cop shootings that I watch. And that is an accurate statement. It's crazy. And they're going after him.
That's really what the jury's being asked to determine. And yeah, there are instances that you could imagine where the person actually would have freedom of choice and a conviction could be appropriate. One might not expect that to happen under most self-defense circumstances, but although for an intentional, then he'd be guilty because he intended to kill someone else.
And here's my only argument is, I think the testimony was the bullet that has endangered McGinnis passed through Rosenbaum, right? That Rosenbaum was shot, there's 5 wounds with 4 shots. So he didn't miss. So the reason that I'm kind of hung up on the utter disregard for Rosenbaum is if he would have missed, I suppose, and you could say that shot was a wild shot.
But he was using steel-jacketed ammunition.
Bullets are bullets, Judge.
No. I'm picking at hairs because that's what we lawyers get paid to do. But and of course, if we were in the jury room and we'd laugh at each other for the things that are being said. But in the eyes of the jury, they could theoretically, like how many angels fit on the head of a pin, they could theoretically think, well, it does make a difference because he wasn't using expanding ammunition. He was using a full metal jacket, and he should have foreseen that it might have gone through and that it would endanger someone else.
The defendant also did not know he was there, so the jury could very
He
easily...
did indeed. That was my next point.
Well, my only argument, Judge, was that if he's using utter disregard.
Anybody ever heard of law enforcement getting charged with this when they miss completely? No.
The jury believes there's utter disregard as it relates to Mr. Rosenbaum. The charge as it relates to Mr. McGinnis directly relates to the bullet that went through Mr. Rosenbaum's hand or head or whatever. Right? So that's why I'm saying if it's that for Rosenbaum, it has to be the same for McGinnis, only because there's not a wild shot. He didn't miss. He wasn't spraying. Nobody's alleged anything like that.
You could say that in your argument, couldn't you?
We
If I left this on their verdict and you had argument, you could say.
I certainly could.
Pardon me?
I said I could.
The evidence does show that he essentially missed the third or fourth shot. There's a graze wound that then traveled who knows where, possibly towards Mr. McGinnis. So this is not as though all 4 bullets entered Mr. Rosenbaum. One skipped right by him and basically a contact wound. And the defendant says he didn't think he was there. So a reasonable jury could find that how do you show utter disregard for Mr. McGinnis when the defendant claims he didn't even know he was there?
A reasonable jury could find. Really? You guys can't figure it out. I mean, it's just crazy, people. I hope people are waking up to the injustice of our so-called justice system, because it's absolutely crazy. Why don't we charge Rosenbaum for moving his head and causing the bullet to ricochet? Because Rosenbaum was the last person that touched that bullet before it ricocheted. Therefore, he should have liability if somebody got killed by that bullet or threatened that, and we should charge Rosenbaum. And I think a reasonable jury could infer that, Judge. Fucking idiots.
I'm going to think about this one. My inclination at this moment, to repeat my former statements that have caused some consternation, my bias would be in favor of submitting that verdict and giving this instruction. But if it shows up on your doorstep, your email doorstep tomorrow at some point, and it isn't in there, don't be terribly surprised. All right. Count 4.
So count 3, it's essentially the same issue, except obviously this time the defendant knew he was there. I'll essentially my arguments that I believe firing 2 shots, missing, a reasonable jury could find that he was not showing utter disregard. He only fired twice instead of 4 times. He did not fire into the individual after already striking him twice, as he did with Mr. Rosenbaum. He did not continue to fire. So I believe the mere fact that he fired twice and did not hit a reasonable jury, and again, we believe that first degree is the most appropriate charge, but a reasonable jury could find that because he stopped firing, he was not showing utter disregard.
We are talking now about a jumpsuit? Jump kick.
Blue hoodie man?
What do you call him?
Blue hoodie man?
What do you mean?
No, absolutely.
Did you want to respond?
It's the first time I've ever heard that missing someone when you're firing from point blank range means that you're not showing an utter disregard for human life. So he fires Judge, he's on top of him when he kicks him in the face, and you saw the shots. It is difficult to ascertain an argument that a jury would believe because he stopped shooting or missed from point blank range with an AR-15 that he wasn't showing utter disregard for human life. I don't think that's a logical argument. I think the appropriate instruction is 1345. They're either going to accept that it was self-defense in that or they're not. But to say point blank range, 2 shots on a man jumping on you, yeah, that might not show an utter disregard for human life because either he missed or he stopped. I don't buy that as logical, and I would ask that you just give 1345.
If his conduct, the standard for the lesser included, I think, is still there is ground in the evidence for acquittal on the greater and conviction on the lesser. The same set of facts. What's the difference between what you're charging and the lesser?
I've stated what I think the difference is. My worry is that the defense, I've asked now a couple times if they're just going to agree that there's utter disregard, and they've not agreed to do that, is that they're going to get these instructions and then argue it in their closings, and then we are stuck. So I would like some sort of limitation.
Why wouldn't they argue in the closings what the instructions are?
That they will argue that there's not utter disregard. That they will argue the opposite of what they're saying now.
No, I'm not hearing that.
Well, then why not agree to it? If they are agreeing that there's
They'd be nuts. That's why. How would that be?
What's that?
They'd be nuts. Why in the world would they concede an element like that?
Well, they're conceding it right now.
No, they're not. They're discussing it for purposes of whether or not the lesser included should be given. They're saying, they're not conceding all your evidence. They're saying it's hard to believe that this would constitute or not constitute utter disregard for human life. Let me repeat the question I just asked you. This is not. I don't think there's a dispute in the evidence as to this individual, Mr. Jump Kick Man. The video is claimed to depict that he kicked the accused in the head. That the accused turned and fired at him twice and missed. On what ground could they convict him of the lesser without having convicted him of the greater?
Well, I'll stand by the prior arguments of the defendant's own statements. And also, I think it does make a difference that he shot 4 times at Mr. Rosenbaum. after he was already crumpling to the ground. That the fatal shot was as he was falling to the ground, and he stopped shooting.
Remember, those 4 shots was in less than 1 second, 0.75 seconds. And he's arguing that, oh yeah, he should have stopped after the 3rd shot. Really? I mean, it's just crazy. How many cops have shot people falling, once they hit the ground, continue to shoot, then say they moved and fired multiple rounds after they were laying on the ground? Never this question comes up. Perfectly okay. Outrageous.
At the man in the blue hoodie. Again, I think the first degree is the appropriate charge, but I think a reasonable jury can say, why did he stop firing? Why didn't he, fire at him as he went away? I feared he might come back and run.
A reasonable jury would see that this whole trial is a fucking scam and vote not guilty on everything and say, screw you. Wasting our time, government money, and dragging this kid and witnesses through the mud so you guys can play tough guys and cool Laurel and Hardy show.
Adam. So I believe a reasonable jury could find that. And frankly, if the defense, in their closing argument, tries to quibble with the utter disregard, I don't know if it's precedent before, but I think we're going to ask for lesser included after that. Because we're going to ask for lesser included after that. If they're admitting here that there's no way a reasonable jury could find otherwise, if they're agreeing to that, that's one thing. But
Well, if they're agreeing to that, then why are you asking for a lesser included?
well, they're not agreeing to it.
But I understand. I actually do understand what you're saying, I think. But let's do it again. Let's talk about the incident involving Jump Kick Man. What he was doing, what the defendant was doing, firing a gun at a human being.
Yes.
He hasn't alleged that he wasn't firing at him. He wasn't saying I was just trying to scare him off with a couple of shots across his bow. He didn't say that. Why he was engaged in it, and he's given his reasons, and I don't think the state disputes them. He was doing it to prevent the man from attacking him, and the state says the man had the right to attack him, and the defense said he didn't. Either way, he was doing it for what he was doing. It was purposeful. How dangerous was the conduct? Well, the defense is not disputing it wasn't dangerous behavior. I don't think they're going to argue that. How obvious was the danger?
The defendant denied that it was obviously dangerous. He said he did not know if it was going to kill him. He did not know that he denied knowing or that his bullets were more dangerous than other types of bullets. He denied knowing that his gun was more powerful than other guns. So again,
So now, no matter what bullet you buy, you're screwed. Because if you buy Full Metal Jacketed, you were endangering the public because your bullet would have went through. If you buy hollow points so it doesn't go through, you're going to be charged with aggravated murder because it did more damage. And isn't it true that you brought hollow point bullets so it would expand in the body and do more damage? Isn't it true that hollow point bullets expand in the body and transfer all the energy, and no energy is lost, and therefore they're much more damaging rounds? Damned if you do and damned if you don't. Whatever government wants to put you in jail for, they can and they will. Our system sucks. And so do freaking DAs and lawyers and attorneys.
the evidence most.
I don't think that is exactly what is stated. For example, the discussion about what type of guns are more powerful. That wasn't actually it. I was kind of intrigued about it because it was a close contact, and the suggestion was being made by the questioner, Mr. Binger, that the rifle is because it's a more powerful weapon was more dangerous or something to that effect. And of course, in a close contact situation like that, it may be that the pistol is a much more desirable weapon. I thought that discussion was focused.
Isn't it true that you brought a rifle because it's more powerful and the bullets would go through? And if you used hollow points, it would do more damage. And if you brought a pistol with hollow points, you wanted the bullets to stay in. And if you bought a pistol with regular bullets and it went through or ricocheted off, all bullets can ricochet, all bullets can go through, including hollow points, and all bullets can stay in the target. This is a bullshit smoke and mirror argument, and it's freaking wrong. It's just dead wrong.
On that type of issue, rather than your claim that the defendant was suggesting his weapon wasn't dangerous? That it wasn't obvious? The danger wasn't obvious?
So if you put premium gas in your car when you had a wreck, you knew it would make your car go faster, and you wanted to go faster because you brought premium gas, right? So now the next thing is what gas? And if you put tires rated at 100 miles an hour, you knew you were going to be speeding. Your tires should only be rated at the speed limit. Otherwise, it proves that you knew you wanted to speed, therefore you got tires rated higher. It's just absolutely outrageous how they're making this shit up. Get a little weasel.
Judge, in his testimony, the defendant said, essentially, I was in fear for my life, but I didn't mean to kill him.
Is that what he said, or did he, when he was asked, did he mean to kill him, he said, I was just trying to defend my life, or words to that effect?
He said, I did not want to kill them.
Did he? I don't remember. Mr. Binger says yes, Mr. Krause says yes.
He said,
I think that's fair. At some point or another, he did say he didn't want to kill anybody. That's true.
That night.
But that's not the element. For that, if we're first degree, then that'd be another matter. This is reckless endangerment.
We're talking about the defendant's mind if he had utter disregard.
No, we're talking about.
Who thinks the jury should have to sit through this? Who thinks if we want to get a reasonable jury to give a reasonable verdict, why wouldn't we want the jury sitting through this right here? I mean, to me, that's just such an easy question. What? Anytime you give government the ability to operate in secret, it turns out bad. It's always bad. Freedom dies in darkness. I'm telling you, tyranny grows in darkness. When government gets to be secret or do things out and control what you know and what you don't know, who controls the information, controls the people, the lawyers and the judges control the information, and then they blame the jury for giving a bad verdict. It's just bullshit.
How obvious was the danger?
If we agree, the state, under their evidence, is shown utter disregard. What we're fighting about is that it's not.
I'm still struggling with what is the basis upon which the jury could acquit of the greater and convict of the lesser, because that's the standard.
If they believe the defendant, they have a basis for the lesser. There's a basis. If they
Defendant
accept the defendant's
I didn't want to kill anyone.
That I didn't want to kill anyone, that he bought the gun because it was
That would be
cool.
that. I might even buy into that. I might. Except that that would be if we were talking about a charge of count four. Because intending to kill is not an element of this crime.
But it shows that I utter disregard if he's firing and not
So
considering.
you're getting to the ultimate fact. And I'm telling you what the factors are in determining whether there's utter disregard, and you're telling me that one of the factors to be considered on whether it's utter disregard is utter disregard. That doesn't make any sense.
Well, like I said, I believe the defendant's testimony gives a reasonable jury a basis to find a second degree.
I don't. So I will not give that instruction. Or submit that verdict.
I freaking love. Now look, people, this judge is kind of giving judges a good name, and it shouldn't. There are so many different types of judges, just like any cop, any lawyer, any judge, any nurse, any fireman, any doctor, any profession. You've got some cream raises to the top, and you've got the rest below. This judge is doing things that I do not see most judges do. And I think the reason is he's been on the bench for so long. He's at the end of his career, may not be thinking another term, and he just doesn't give a shit. And he's seen so much bullshit through his career that he goes, I'm going to do what's right. So don't think that because this judge is good, man, it's a good thing we got good judges. We don't have good judges. There are much more mediocre and bad judges than there are good judges. There are much more mediocre cops and bad cops than there are good cops. And when I say good, I mean the top of the litter, top of the box, top of the cream, drivers at the top, whatever, however you want to say it.
And the reason is because I do not feel there is a basis in the evidence for acquittal on the greater and conviction on the lesser.
Wouldn't you love to be a juror and know what the hell's going on here and what the defense is trying to do and how much effort they have to go through in discussion just to figure out? They're going through more deliberation just to figure out to tell the jury than they want the jury to come to a verdict. It's just crazy.
You're asking for second degree intentional, or first degree reckless or second degree reckless.
Yes.
So now give me the bases for acquittal on each of the greater crimes and conviction of the lesser?
Well, with first-degree intentional homicide, obviously there's self-defense. The jury could find imperfect self-defense and find second-degree intentional homicide, that if he did not reasonably believe the force, if it was not reasonable for the amount of force used. The defendant, again, while testifying, said he did not mean to kill Mr. Huber. So they could find from that alone that there is not an intent at all and go to the first-degree reckless. And then we're left with the argument that we've been having all morning thus far, which is whether a second-degree reckless showing utter disregard would be appropriate.
You hear that woman telling him to slow down? I've heard that for, I don't know, probably my entire career. Who's ever freaking typing? Slow down. I'm not sure. And they make mistakes. If anybody thinks this court reporter does not make a mistake, you're freaking crazy. They are sitting there flirting with the lawyers. They're not paying attention. You read the transcripts sometimes, and I'm like, that's not what was said. But that's the transcript, because she's typing in the middle of all this changing. And every time she types, she has to say who said it first and who's talking. And if you don't think they're a mistake, it's great. In this day and age, with digital recordings, and you could have multiple backups, you could have alternate mics, you could have somebody check it at the end of the day. I mean, in all of this, we still have a person getting full benefits, making 60, 80, 100 grand a year to listen to this bullshit and to type. And then when she sells her transcripts, each attorney has to pay for it. The government doesn't have to pay for it, but the defense has to pay for it if they want it typed out. So she gets full benefits, medical, child care, child maternity leave, all the shit that government gets, so she can sit in here and type. Because getting top of the line microphones and recording equipment would somehow be less expensive, and government could never do something that's more efficient and less expensive. It's just crazy. And of course, the court reporters will always fight against that because they don't want to lose their job.
The defendant said he didn't mean to kill him. The defendant gave his reasons why he thought he had to shoot him. But again, I believe he indicated he denied that he knew it would kill him. And essentially, it's the same argument that's been being made all morning. But I think it's quite clear that in a self-defense case, second-degree intentional is appropriate because the jury could very easily find in this case that it was not perfect self-defense. As a person who is running at him, being told, or perhaps even witnessing himself, that the defendant has already shot someone, gravely injured them, has already shot at another person missing, and then gone in to try and disarm him. The jury could find that it was not perfect self-defense.
Are you disputing that?
No, first and second?
First and second,
No.
intentional or okay?
Yeah.
Okay. So again, the reckless, the defendant testified directly that he did not intend to kill him.
Any dispute as first degree reckless?
No.
Okay. All right, any objection to second degree reckless?
For the exact same reasons that we had talked about, Mr. Huber, I'm sorry, Judge, if you already...
No, that's all right.
Mr. Huber has the evidence was a rifle pointed up against his chest.
I didn't hear you.
He has a rifle, according to the evidence, he has a rifle pointed literally up against his chest. So the idea, under those circumstances, that having an AR-15 pointed, buttressing up against your chest would not be utter disregard for human life if believed, to me that's where it begins and ends. There is no other explanation. So I think first degree, second degree lesser included, first degree reckless are all appropriate. Second degree reckless doesn't fit.
Did you want to respond?
I'll just say in my arguments before, this afternoon we may review the defendant's testimony, and if I find a specific thing that I think changes it, I will obviously contact the parties.
Okay. I embrace the argument of Mr. Swarovski. Then count 5.
Okay, one more thing on a court reporter. I'll tell you something else that most people don't know. In the military, for military court martials, which is basically a trial just like this, but it's done with military officers, a judge or a general sits up there. He's called the judge advocate. The JAG, judge advocate general, is usually the judge, or they assign a judge, or they pick a judge, and they're lawyers. They're all in the military. In those courtroom proceedings, they don't have somebody typing out every word that's said. You're probably thinking right now, oh, that's smart. Why don't... They got some idiot with a freaking mask over his face repeating everything said. Judge said blah 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 blah, and the court wrote, and the answer was, the respondent said, and he sits there, and I've never seen one of those guys tell somebody to slow down. Now you talk about inaccuracy. You've got two people talking and arguing back and forth. You got questions and answers and different things going on, and this guy's sole job is to repeat everything said by whom in a little mask over his face. And that's how the military keeps track of their trials. Man, isn't government great? We're so lucky. If we only gave them more money and more government, we could have more of this efficiency.
You are, and that is the shooting of Mr. Grosskreutz, and that is charged as intent to kill?
Correct.
Okay.
So the instruction I requested is attempted first and then attempted second for very much the same reasons as Mr. Huber, that a reasonable jury could find imperfect self-defense, as Mr. Grosskreutz was actually facing away from the defendant when he fired. And then the next lesser included, if they don't find intent, is the first-degree reckless endangerment. So I've requested that, and then obviously I've requested secondary reckless endangerment, which we've rehashed a few times now.
Defense?
Judge, I don't have an objection to the lesser included on the second-degree attempt. It's the same argument. The court heard the evidence. In the distance, Mr. Grosskreutz testified that he was about 3 feet away, whatever it was from him, when he was shot. The gun, Mr. Grosskreutz pointed the gun at the defendant. Mr. Rittenhouse then fired. So I think that attempted first degree, well, you can't attempt a reckless act, right?
I would have told you, I would have agreed with you some years ago, but I'm not sure. I don't know the answer, and I certainly am going to have to hit books on that. That was certainly once the law.
I would have, you either are, to me, you're either reckless or you're not reckless. So I would object to any recklessness because I don't think you can attempt a reckless act. So I'll leave it at that and let the court counter that.
Well, the defendant did testify that he didn't want to kill anyone.
I understand that. But I think somebody would say the behavior is either reckless or it's not. I don't know how you can attempt to be reckless or attempt to be negligent. I don't know how you can do those things.
Judge, if I respond, I mean, we just basically agreed on the comment by Mr. Huber that reckless homicide is appropriate. Mr. Grosskreutz did not die, so the appropriate charge at this point would be the first degree recklessly endangering safety. The jury could easily find that the defendant intentionally shot Mr. Grosskreutz, which is not, I guess, a dispute, but that he did not mean to kill him. The defendant said multiple times, I did not want to kill anyone. The jury could also find that shooting someone in the arm, if they find that was where the defendant was aiming, would not be intent to kill, but it would be recklessly endangering his safety. If the jury does not obviously find that it was perfect self-defense.
Is it a lesser included?
Yes.
Statutorily?
Yes.
Yeah, I think you're right. Because otherwise, why couldn't they convict him of both? But why get into a discussion we don't need to resolve? We'll do it later. I don't know. I'm going to think about this one. I'm inclined to agree with Mr. Krause.
I wonder if the jury was in the courtroom, what they would be thinking right now, and with who they would agree with, and what they'd probably just go, "This is all freaking a bunch of bullshit."
Okay. Now the defense has submitted, and I don't think you submitted anything standard except standard on that
Our position is they've never raised the affirmative defense. So that's why we didn't do that.
at the trial.
Correct.
Let's see.
And obviously they can argue otherwise, but that's why we did not prepare one. Obviously they can argue otherwise, but that's why we did not prepare one.
Correct me if I'm wrong. As to the third element of the second defensive matter, which you cite on the second page, on the third page, item number 3 on the third page. I don't recall that evidence.
I would agree there was no evidence that he...
How can I give that instruction? Oh, because they have the burden of proof.
It's not a strict liability offense. He's like 17 years old.
Yeah, if there's an absence in the evidence, that's kind of a problem for you, no?
What do you mean?
You would need to disprove the affirmative defense.
We don't believe it was ever raised. They never gave any evidence as to barrel lengths or that.
Oh yes, there was definitely barrel length evidence.
On cross-examination of a state's witness.
Whenever it happened, it was there.
And
No, I'm not sure. There was evidence of the length. He had the ruler out and he had measured the length of the portal.
I asked Tech Van Ringen.
Did you?
Yep.
Assuming that to be true, then that would, then that was less than. Excuse me, it was the barrel length was greater than 16 inches.
Sorry.
Wait a minute. Either the barrel length was less than 16 or the overall length was less than 26. That was in the evidence.
What I asked him was there any? Did he believe? I want to make sure I have it right so I don't misstate it. Did he believe that the barrel length was in violation of the law?
What law? I mean, there may be. I don't know what laws there are.
There's plenty of laws. Under 16 inches for a rifle, if it's got a stock, the ATF will tell you in the laws. Why didn't the prosecution pull in that if they wanted to go there to prove? I think they're trying to get something in on the legality of the weapon being illegal, yet they didn't freaking prove that the gun was illegal.
That's
the law. You can't have a
You're
gun.
talking about, okay.
And that's built into
Okay.
this
Well,
instruction.
he certainly, come on, it's not a strange issue in this case. I mean, we've been talking about it for months.
Well, and I agree with you for months, and the defense should have measured the barrel in front of the jury and said the
You
barrel.
have the burden of proof.
That, they didn't, if they raised it, they never raised this issue.
Well, did he ask the detective whether it was a? What was your question? As you were
Illegal.
voting, and this is going to be dependent upon what the actual evidence was. But what do you claim it was?
When he took the gun from the Antioch Police Department, did he believe that there was a violation of the law as it related to the barrel length?
That's because of his belief, and they never specify which law.
They have to raise the issue.
I understand. I don't believe that they have. There's no testimony on the authorization, the certificate of accomplishment to obtain authorization for hunting. There's no evidence on whether or not he has a certificate of accomplishment to obtain authorization for hunting, which is the state's position all along, is that he would have to have that.
Well, they're claiming it's in the alternative.
And the state has always claimed that it is not. So we're back at, well, if the court finds they raised it, which I don't believe asking a general question on the belief of a detective, that is not evidence, the belief of someone.
Well, is it a belief or an observation?
The way Attorney Prosecutor said it was belief. We don't get the exact question, but I don't believe.
I believe that question may become important.
So I don't believe that is raising it. And the defense had every opportunity. They brought the gun over here most every day the last few days. They could go to any number of witnesses to measure it and raise this issue, and they did not.
They don't have to measure it. That's the burden of proof of this on the state.
I understand that, but it wasn't raised.
Well, if he asked the officer, and I will have to see what the transcript says, if he asked the detective whether the rifle was compliant, or what are you claiming you said?
I asked him if there was. I know I asked him about it. The question I asked, I think I asked him something along the lines of, "Did you believe there was any violation for the barrel length of the gun?"
Lucky question. Neither one of these sides thought about it till right now when it's an issue. That's what you call a lucky question.
So that would put it in issue if the question is like that.
Well, also the statute reads, this section applies only to a person under 18 years of age who possesses or is armed with a rifle or a shotgun if the person is in violation of section 941.28 or is not in compliance with the two sections mentioned. So it's an or, it's not an and. We don't have to show all three. So they may have raised the issue with...
You have to show one of the three. You have to show one of the three. No. What am I saying?
No, we have to show...
You have to show any of the three which the defense has put in issue.
So-
The defendant has not put in issue the certificate of accomplishment.
Correct.
The defendant has put in issue the length of the barrel.
And Judge, we can unpack this for a minute. So the exception says it's a violation of the law if you're under 18 and possess a short barrel shotgun or rifle. Okay, that's one way you can be convicted. And it says or are in violation of Wisconsin statute. I think it's 29304. 29304 only applies to people 16 years of age or under.
Right.
There's been testimony that he's 17.
No.
Okay, so I've conceded because he has to be in violation of both 29304 and 29593. I concede he's in violation of 29593. However, 29304, he's 17. It doesn't apply to him. It can't apply to him because of his age. We put in his age and we put in the barrel. That covers the first exception, and then it goes to or, and it covers the second exception as well. I provided the court, and I'm not rehashing it, that you had denied the motion for reconsideration. This statute doesn't apply to 16 and 17-year-olds, period. The legislative history that I provided to the court, it says it in black and white.
Well, I wrote as I did because the motion to dismiss attacks the complaint. And the complaint was adequately pled under the law. That was not an endorsement of the state's position on the case. And to use a trade expression, the rubber hits the road here at the trial. So now you have to prove everything that the statute requires. And do you dispute the fact that you need to prove that the defendant was under 18 at the time of the incident? That's not in dispute.
He's under 18, yes.
And that the barrel length was less than that allowed by law. Or was it not within the range permitted by law?
We don't have to prove that.
You don't have to prove it.
I mean, there's no real... Our argument is that they did not raise it. I don't think it's really a disputed fact. But we believe they did not properly raise this first part of the exception. The second part of the exception, they've conceded 29.5...
Go ahead, I'm sorry.
They've conceded the 29.593 portion. You do not have a hunting certificate. So then we go to 29304, and if it is allowed...
Oh, if he had a hunting certificate, this would be a moot point. Get your hunting license if you're going to a riot carrying a gun, people.
That simply being 17, he is in compliance with that. It swallows the whole statute, and the statute makes no sense. So if the statute...
It makes no sense. You're out of luck.
Well, the statute is valid. It's clear as day that it says a person...
It's clear as day. I would not say that about this law.
Well, I would maybe not say that about the exception, but the actual law, 2A, is quite clear. Sure. Any person under 18 years of age who possesses their guns...
That's not the whole statute. That's not the whole statute.
Our position is that he is not in compliance with 29.304 and 29.593. And I know that this was scoffed at when I mentioned it before, but 16 and 17-year-olds can hunt alone in this state if they have the correct certificate.
Okay.
Under 16 cannot, and that is what 29.304 is addressing. The statute is addressing hunting.
No, the basic law is that the rubric is not part of the statute.
The rubric?
The title.
The title is possession of dangerous weapon by a person under 18.
It's not part of the statute. No, I learned it in an earlier time when we called it the rubric.
That's what the statute says, though. That's what it says in 2A. And the state's position is that he is not compliant with those two, and that they have not raised the short barrel shotgun issue, the short barrel shotgun issue. But they don't really have to because they can try to raise the other part, but they have not done that either.
He didn't have a shotgun. I don't know why they're talking about a short shotgun, because a short rifle and a short shotgun is different.
By his age, he's raised. On the second part. It's raised.
Yeah, that's true.
So that's it. And I just want to make sure, I've been losing this argument. It's not, Judge, there are hunting portions of that statute, and there are just simple possession portions of that statute, of 29-304. I am not focusing, and I'm asking that it doesn't apply, the hunting part. If you read the Legislative Bureau, what it says is, if you're 16 or 17, there is an exception for you to possess a firearm,
It does say that.
semicolon, done. It has nothing to do with hunting. Nothing.
My inclination now, once again, I'll tell you what I'm inclined to do, is to inform the jury. Let's see.
So you interpret the statute in a way that makes sense. And the way that it makes sense is that simply because he's 17 does not automatically negate 2A.
Well, I raised it earlier in the case, and it hasn't enjoyed a lot of discussion, and maybe I'm off the wall. I think so. The penal laws are construed strictly. Vague laws are. Who is that emperor from way back in history who posted the laws on pillars so high that the people couldn't read them, and that's been used by lawyers and judges for centuries about the requirement that people be given knowledge of what the law provides. And the basic law, and it's chipped away a lot of times with the appellate court decisions that are made on the subject of in efforts to preserve the statutes, because some of them are quite messy. And that's not a criticism, that's a reality that judges have to deal with periodically. Most of the statutes are easily enough worked with. But the basic rule is that the ordinary people should be able to understand what their laws are, so they know what conduct is allowed and what isn't. And I've been wrestling with this, and now I know that there's a lot brighter judges in this world than me, but I've been wrestling with this statute for, I hate to count the hours that I put into it. I'm still trying to figure out what it says, what is prohibited. Now, I have the good fortune of having some experience and a legal education. How is the ordinary citizen supposed to acquaint herself with what this law says?
Judge, there's testimony that the defendant, Mr. Black's stepfather, the defendant's mother, all knew he could not legally possess this gun. That's why he was kept up here. That's why Mr. Black bought it. This today is very clear.
Interpreting a penal statute?
I'm sorry?
Is that the standard by which the judges interpret a penal statute?
It's clear to normal everyday people, and it was clear to these normal everyday people. Because it's very clear that under 18 cannot possess a dangerous weapon.
The law. And he can't necessarily possess the gun in Illinois. We're talking about Wisconsin, and we're talking about the law, not what Dominic Black's father might think.
I'm simply responding to your...
Well, but the point is, if they put a sign out here, don't jaywalk over to the other side of the street. And that's a bad example because we know jaywalking is unlawful. Supposing they put a sign out there that said, don't use your cell phone while crossing the street. Now, if they adopt a law that says that, and people are, as I told the jury before, ignorance of the criminal law is not an excuse, so people are charged to know that, unless it's written on the top of a pillar so why people can't see. But people, if they're given legal notice, that's why they publish them in the newspaper. If people are given legal notice of what's unlawful, then they can conform their conduct to the requirements of the law. If they don't know what the law is, then they're just herded into obedience of certain standards. Now, I don't know if that's the case with Dominic Black's stepfather or father or whatever it was, or the defendant's father or whatever. Whether they studied the law, they were familiar with what it says, or they were just afraid to break the law because they heard somewhere along the line that it was unlawful. Well, I'm not allowed to do that. I'm not allowed to say, well, they should have guessed right. I can tell you, I've put many hours into it. So have you. And how are ordinary people not supposed to know what they should be afraid might be against the law? How are ordinary people supposed to know what's against the law?
Who thinks right now that you know what's against the law and what is? And you go a day. I guarantee you every freaking person in the sound of my voice commits at least 1 to 5 crimes a day that the government could cite you, fine you, write you up, give you notice on something you do at least 5 times a day, unless you're sitting in your house doing nothing. And then even then, they can probably get you. Failure to water your lawn or turn off your Christmas lights or something.
2A is very clear.
Wish it were me. I'm going to my intention is to instruct on what he submitted, without page numbers, I might add. Looks like the third page that starts statutory definition of crime. And down to where it says or. So it'll be exception, the state must prove, etc. Then number 1, the defendant was under 18. Number 2, and that the dangerous weapon was either a rifle, etc. And you can search the evidence to find out if you can prove beyond a reasonable doubt that that's true, so that it can go to the jury. All right, now, is that it?
The state requested the 805, 810, 815, as well
Yes,
as
any
9.
dispute as to those?
805, no.
Okay.
810 and 815 are the retreat and provocation instructions, so yes.
Okay, go ahead.
Well, I guess I would ask this first, Judge. As it relates to 815, which is the provocation instruction, is the state saying the presence of Mr. Rittenhouse there is in and of itself provocation?
No, we are saying that in the incident of Mr. Rosenbaum, he provoked it by raising his rifle and pointing it at individuals. So that is why Mr. Rosenbaum then gave chase to him. The defendant then had a duty to retreat. He retreated. Instead of giving notice of his withdrawal from the fight, he turned and pointed his gun again at Mr. Rosenbaum, an unarmed civilian, which he admitted he knew he was unarmed, and that continued. So,
Oh, this place must have a duty to retreat. California used to have that. I don't know if they still have it. But if somebody wanted to fight with you, you have a duty to walk away and not fight. If you just stand up for yourself and defend yourself, you were wrong. And that's where all socialist country goes, because right now people write me all the time, either from Australia or the UK, and tell me, if somebody breaks in your house, you cannot interfere with them stealing your stuff or you will be charged with a crime. You must watch them and not interfere. And if you do interfere and they get hurt, the criminal can sue you. That's what liberalism is.
So no, the provocation is not his mere presence. It's not his mere presence with a gun. We will argue that the video evidence, contrary to the defendant's testimony, shows that he raised his weapon at individuals, and that is what provoked the attack. Mr. Rosenbaum.
So, Judge, yesterday, obviously you know why we were fighting about what that enlarged photo, and I don't think that's what I think that evidence is open to interpretation, certainly. I would argue to the court that while Mr. Krause can say that's what they believe it shows, I would submit to you that what the testimony is Mr. Rittenhouse is shortly before that yelling friendly, friendly, friendly. I think if you look at that picture that you saw yesterday, it's open to interpretation. We know he's wearing a strap from the harness over his shoulder. The other thing that if you look at the picture closely, he's standing like he would be firing or pointing that gun like he's left-handed. So if you look at the picture, his left foot is back, his right foot is forward, and he's open like you're looking at me now. So in every other instance where you observed a gun being fired, he's firing it from the right side with his strap as his gun hangs this way. Now they're saying that photo shows that he was standing and picking the gun up and doing it left-handed. I think that photo is open to interpretation as to what it is. We believe that it shows a side mirror of the Duramax and part of his strap from his firearm, or from his sling. That's open to interpretation. I completely understand that. However, you also heard testimony that from this person from the State Crime Lab, who said he couldn't really answer, and I don't know what you thought of his testimony yesterday, but he really couldn't answer a lot of questions on, and that's why color was so important yesterday, on how the pixels work, and he couldn't say what color those pixels add, and I think that's relevant. Now, it is our position, and I think the testimony supports the idea that Mr. Rosenbaum provoked the attack.
Mr.
Rosenbaum provoked the attack. Mr. Rosenbaum, there's testimony from two people that Mr. Rosenbaum threatened to kill Mr. Rittenhouse if he caught him alone. You heard the testimony that Mr. Rosenbaum yelled.
Which is really, can you imagine if nobody heard that? I still think Kyle is justified in everything he did, even without that. But because of that, it really gave him a lot better umbrella of protection than without that.
Gun, gun, gun. Then you know what was said after that. He's chasing him down. He yells, there's been testimony that Mr. Rosenbaum yells F you before this happens. Mr. Rosenbaum has a gun pointed at him in the parking lot and doesn't stop running toward Mr. Rittenhouse. And if you give 815, which is the provocation instruction, I would submit to you the only way that Mr. Rittenhouse then can be acquitted or found not guilty of the charge is, one, he exhausts every other reasonable means of escape. Two, he withdraws from the fight, and fight is the language in the instruction. And three, he provides... Sorry.
Well, go ahead, finish, and then I'm going to tell you why I don't agree with what you're saying.
Okay. Well, I'm looking at 815, but...
I'll interrupt you now and tell you.
Okay.
You said, if I give that instruction,
Yes.
then the only way, no, the jury may not believe the predicate facts upon which the instruction is based. So he could be acquitted, as long as the jury does not believe that the defendant's behavior was provocative.
That's the first line of the instruction.
But, say that again?
That's the first line of the instruction. One should also consider whether the defendant provoked the attack. The defense is still able to give forward their version of events. We have multiple videos in addition to this photograph, and also a defense exhibit number 41, which has its circle on there where the defendant is raising the gun at someone in front of that Duramax. That's an exhibit they have gotten into evidence. So there really wasn't much dispute this until 2 days ago, and that's fine. They can dispute this fact. We believe it's very clear on video that the picture itself is just one little portion, but on that drone video, both the full version and the somewhat zoomed in version that has been provided, it's very clear.
Thanks to Fox News, they got that drone footage. The government didn't have that footage until Fox News played it. Again, Fox News didn't know that. They're putting out the news. Is that good or bad? Unfortunately, it appears they're going to use it against him.
I saw it on my television at home immediately upon watching it. So that's our argument, is that he provoked it by doing that. Now, as the court has pointed out, this is not forcing the jury that there's provocation. It's not forcing their hand. They don't have to find provocation. You should also consider whether the defendant provoked the attack. And that is a consideration, and that is a point of contention in this case. And I believe it's an appropriate instruction for both incidents.
No, that's okay. The last thing that I was going to say is it would also require that he give Mr. Rosenbaum adequate notice that he is withdrawing from the fight or the attack. I think under those circumstances, that's impossible to do. But more importantly, I have found a case, it's from Kenosha, on provocation and what that means in terms of a self-defense. That is State versus, and I'll just spell it, it's B-O-U-G-H-N-E-I-T. B-O-U-G-H-N-E-I-T. It's at 97 with second 687. And in that case, there was a gentleman in a diner, and people walked into the diner and he started to harass them. He tried to grab the women, harassing the women, verbally accosting people. And one of the men that the women were with came over and said, "You need to apologize." The defendant said, "Let's go outside." So they go outside. The defendant ends up going to his car, picking up a shotgun and shooting the man in the face. And the argument was, did he provoke this? Now, there was testimony to everything that I just told you. Did he provoke that by starting the fight, sexually harassing the women, using the language to use, and then ask the guy to come outside? And the court said he did. So the provocation instruction is clearly appropriate. I don't believe there's sufficient evidence in this record to support the idea that Mr. Rittenhouse provoked this attack. I don't think that's there. So I understand that it doesn't require that they follow that and say, well, he did provoke it, but I think there has to be evidence to support that. And I don't think that photograph in and of itself, which is obviously open to interpretation, supports the idea that they have to or should consider whether or not that was provocation at that point.
Not only
I agree with the photograph alone.
Not only is the photo up for interpretation, we're expanding it, adding colors and changing it, and there's even an issue of whether it's valid. And now we're going to use that to get an instruction in that really, because if they get the provocation instruction, they're kind of saying, look what he did, he provocated this. So by provoking, he provoked this. So if he provoked it by pointing the gun, then you can find him guilty and use this and blah, 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 blah. I haven't read the instruction, but I'm sure you could pull it up somewhere.
Would not give the basis for provocation. The photograph is the last piece of evidence that was submitted on this. Detective Venturini testified to it. We have pointed out on videos. We pointed out to the defendant on the video, and he gave what I believe to be a lame explanation for it. And again, the defense's own exhibit has it circled on there as it happened. So I believe there's plenty of evidence that Mr. Rittenhouse did raise this rifle and pointed at someone off in the distance, actually Mr. Zeminski. And let's not forget also, I'm not doing my full argument on provocation yet, the FBI video. Well, let me go back. The Corey Elijah and the Frank Hernandez videos shows the defendant walking behind Mr. Rosenbaum, on the way to this car source area. At some point, Mr. Rosenbaum begins running. We see that on the FBI plane footage. Our argument is that Mr. Rittenhouse then begins running and following Mr. Rosenbaum. That he follows, if not the whole way from the ultimate gas station, then Mr. Rosenbaum starts running. That provokes the defendant, who is actually very slowly and casually walking.
If he's saying he's following him, he has to know he's following him. It has to be an intentional act of following. They never proved he intentionally followed him. They were just walking around a crowd together. He didn't even know if he saw him in front of him. He didn't know who he was, except when he was burning and yelling and threatening to kill him.
For quite some time, seemingly, to then go and follow Mr. Rosenbaum there. He then, and the defense's argument is that this is some sort of ambush. And I don't know how you ambush someone that you don't know they're there, but we'll put that aside.
What?
I don't know how you ambush someone you don't know is coming, but we're going to put that aside. So the defendant runs onto the scene, and then is seen by testimony and video evidence gently putting the fire extinguisher down. He says he dropped it, but he places it on the ground, and he raises the gun, and I disagree about the left-handed thing that Attorney Trofsky just said, and raises it at Mr. Zeminski.
See, I could never make out whether he dropped it or laid it, but they're going to say he lied. Even though he's in the middle of getting attacked, getting things thrown at him and followed, and the guy that's chasing him actually threatened to kill him, they're going to argue, did he drop it or did he lay it down? So the defense needs to put a note of that and say, you're going to probably hear the prosecution tell you that he laid it down. Just because he didn't throw it to the ground doesn't mean he dropped it. He left it. He abandoned it because he knew that he was being chased and he might have to defend himself. So don't be swayed when the district attorney tries to tell you he lied on the stand and that he really didn't drop it. He abandoned that fire extinguisher so he could have his hands free to defend himself and retain his gun so it wasn't taken from him and used against him or someone else. That's what they should write down right now to cover in their closing.
That is all in evidence. It's in a defense exhibit.
Can I see that? Is that really available? Bear with me 1 second.
The state's position is that the running after Mr. Rosenbaum probably in itself was enough to provoke the attack, but putting that aside, certainly raising a gun and with no basis for any kind of self-defense. There's no one around him at the time except an individual in a wheelchair who's behind him. He raises his gun, I would guess because he thinks there's vandalism going on, but we don't know that because the defendant denied that he did it. And then Mr. Rosenbaum approaches, he somewhat drops the weapon, he keeps two hands on it, and then he has a duty to retreat at that point under provocation, and then he runs. I understand why this instruction is problematic for the defense and for their version of events, but that does not change the fact that pointing a gun, which is in the evidence, is provocation.
Well, wait a minute, no. Oh, you will, see if you can find it. Which exhibit are you talking about?
Talking about the compilation video that the defense put into evidence, I believe it's 41.
I have it on my screen right now on my computer, Your Honor.
Then you said, we'll see if you can match it up with what she's looking at. Then you said that something about the one person running after another was provocation. Well, how is that provocation? We're talking now about you're alleging that the defendant was running behind Mr. Rosenbaum, and that was provocative?
That he chased in there.
Your Honor, all about the evidence. He's walking, especially the video that was put in yesterday through Mr. Hernandez.
Yeah.
He's walking within steps. Rosenbaum and Zeminski are lighting the garbage can on fire. He sees my client walking down the street with a fire extinguisher, and there's fires down at car stores. Mr. Rosenbaum knows where he's going. He's already threatened to kill him. He sees them coming. He's got very distinct purple gloves. He goes down and he lies in wait. There's no chasing going on whatsoever.
Where's the chasing? And where's the chasing, and how is that provocation?
The provocation is the raising of the gun.
Oh, so as a moment ago you said that the chasing was provocation,
believe it
which of course it could be.
I believe it adds
If
to
it's
the
in the evidence.
Sorry. I believe it adds to the provocation that he chased him there and then immediately raised the gun.
He wants the instruction, and then he's going to argue what he just said 5 minutes ago.
Well, and I think we're free to argue that.
Just like we're free not to stipulate to the third element.
What am I looking at? There's a circle.
I don't think it's playing yet.
Show me with the pointer what you're talking about.
I'm just pointing out that this indicates he's pointing a weapon.
Huh?
I'm just pointing out that this defense exhibit indicates he's pointing a weapon. We have much clearer video showing this.
And it still has Rosenbaum behind Rittenhouse defense Rittenhouse.
We'll take a minute.
Is he taking a phone call? What the? All right, it's 1 hour and 11. I guess I'll start another one.